Hey everyone, if we're meeting for the first time, my name is Paul Vojchehoske and welcome to the Real Estate Classroom YouTube channel, where my mission is simple: to help you pass your real estate exam the first time. Today we're going to continue our vocabulary word series. We're going to do 188 through 195 of 300. All of our words in this video evolve around foreclosure, short sale, and liens. Now keep in mind, with not only these key real estate vocabulary terms, but all the other ones that we've already done and will do, there are other videos within our playlists that go into deep detail on each one of these and the applicability of them. So don't forget, if you don't understand a specific term that we're talking about, you can always go down into our playlist or our videos tab and search and find a video that explains these in detail. All right, so the first word, 188, we're going to talk about is foreclosure. Now, a foreclosure is a legal process by which a lender, for example, invokes what's called the acceleration clause, key vocabulary word that we've already discussed in a previous video, and takes possession of that property and sells it. And we typically see this when the homeowner defaults on their loan payments or their mortgage payments. Basically, the lender repossesses the property and sells it. All right, now we're going to go into some different types of foreclosures in the next slides, but there are other foreclosures as well that you have to be aware of, in addition to the lender foreclosing on a property. Real estate tax lien or real estate tax deed. Depending on the state that you're in, if somebody doesn't pay their real estate taxes, then there is a mechanism for foreclosure. There is a tax lien, which also can result in a foreclosure. You owe the IRS income tax, for example, or estate tax, something to that effect. And then special assessments, again, that's by statutory and specific states determine what is foreclosurable and what is not. But special assessments is another issue where it can lead to a foreclosure. Again, a foreclosure is just a legal process by which a lender, a government body, somebody that is owed a debt can foreclose. Now we're going to get a little bit more into detail in the different types of foreclosures coming up in the next slides. Number 189 is a short sale. What is a short sale? Well, short sale was really common 2008, 9, 10, 11 during the mortgage crisis. Not so much anymore, but they still do exist. It takes place when an owner sells a property for an amount less than is owed. All right, so let me give you an example what I'm talking about here, and this was very common in 2010, 11, that time frame. So let's say that a property, the actual market value is $100,000. But 5 years previously, the owner, they borrowed $150,000 because that was the market value in 5 years previous. But today the value depreciated, and so the bank is owed $150,000. The actual market value is $100,000. The property, the owner is in some kind of distress, lost their job, whatever the case may be. So the lender doesn't want to deal with a foreclosure. They don't want to own properties. So they agree to release the mortgage lien against the property in exchange for a lesser amount that's owed. So the property is sold for $100,000, and so the buyer can get free, clear, marketable title. The lender will basically release the lien, even though they're only going to receive $100,000, even though they're owed $150,000. Now, the lender does reserve the right to file what's called a judgment lien, or what's called a deficiency judgment lien against the owner or the previous owner or the borrower of that property. All right. Deficiency judgment is a key real estate term that you have to know for your exam, and we did discuss that in a previous video. Deficiency judgment. But it's just number 190, a judicial foreclosure. Now, there's two types of foreclosures we're going to talk about: judicial and non-judicial. Judicial foreclosure requires the lender to actually get a court order. So they have to go into to file a lawsuit, go into court and get a judge to agree to allow them to foreclose on the property. So It is used when there is no power of sale clause within that mortgage or deeded trust. Now, generally, after the court orders the sale of the property, it is auctioned off to the highest bidder. We typically call that a sheriff's sale. That's typically how it's done. Now, this can vary a little bit from state to state. Some states call it a sheriff's sale. Some states call it a foreclosure sale. You have to know specifically for your state side of the exam what specifically in your state it's called. Okay, but this is just generally. And understand that all 50 states allow a judicial foreclosure. This is most commonly used, however, in what we call mortgage states, where those states like Iowa, where they use the mortgage process, the lender uses the mortgage process when they loan money on a parcel of land, versus other states like Nebraska, where I am, we're a deed state and we use deed of trust or the trust deed. So there's deed states and mortgage states, and the mortgage states typically use judicial foreclosures. So they have to get the court's blessing and the court order before they can do a foreclosure. The problem with a judicial foreclosure is it can take up to 3 years before the lender can foreclose after a borrower defaults. But that is a judicial foreclosure. Number 191, a non-judicial foreclosure. Now, remember in the previous slide, we talked about a judicial foreclosure where the lender actually has to file a lawsuit, go into court, get a court order before they can foreclose on the property. That's typically used in mortgage states. Now, in deed of trust states or deed states, which it's commonly referred to, we can, but we're not obligated to use the judicial foreclosure. We can use a non-judicial foreclosure. And the non-judicial foreclosure is, now this varies from state to state as far as the notice requirements, but there are a series of legal notices that are sent to the trustor. Now remember, in a deed of trust, we have the trustor, which is the borrower, the beneficiary, which is the lender, and the trustee, which is that disinterested third party that actually holds legal title to the property. So when the borrower, the trustor, stops making their mortgage payment, the beneficiary, who is the lender, they notify the trustee to issue the notices and proceed with what's called a trustee sale. Trustee sale, that is the actual foreclosure. Again, these are not available in all 50 states like the judicial foreclosure is. It's only available in a deed of trust state. So that's the difference between a judicial foreclosure and a non-judicial foreclosure. Number 192 is liens. The rest of this video, we're basically going to talk about the different types of liens. Now, liens are a legal way to protect an interest of a creditor. All right. So if somebody borrows money to purchase a home, they go to the bank to purchase that home. The lender is going to place a lien against the property in case of default, and they can foreclose. That's a legal mechanism to protect the creditor. A mechanic's lien, for example, a vendor gives supplies, maybe roofing materials or siding materials, and they're owed money. They can place liens against the property to ensure that they get paid. That's what a lien is. Now, liens are commonly placed against property and persons. We're going to talk about that in a minute. As a result of valid debts. So creditors can place liens against properties, but also individuals and government agencies. Remember, if you don't pay your real estate taxes, for example, then the local government can place a lien against your property. If you don't pay your federal income tax, then the federal government, the IRS, can place a lien against your property. Again, place liens against your real property, your personal property, and you, depending on the type of lien and the situation. And that's what we're going to talk about in this video. Also, don't forget there is a lien priority. Now, generally speaking, the creditor that gets paid first is the one that places the lien against the property first. We call that first filed, first claim. However, there are some statutory provisions where some liens have priority. So, for example, if you don't pay your real estate tax and the county comes in and issues a tax lien against your property, either on behalf of the county or on behalf of someone who bought the certificate, then under most states, that has a lien priority. So even though it was filed after, let's say, a mortgage company's liens, it automatically becomes a senior lien. And again, that varies from state to state, but that's what's called lien priority. Now, liens are claims against the property, and they're either granted by the property owner, meaning a voluntary lien. So if I go borrow the money from the bank, I'm the property owner. I'm going to allow a voluntary lien to be placed against the property by the lender, or an involuntary lien, which are placed against the property against the owner's will, such as a mechanic's lien or a tax lien. All right. Remember, local governments can file liens when property owners fail to pay their taxes. And again, liens are voluntary, meaning the owner grants permission for someone or a company to place a lien against the property, and other liens are involuntary, where they are granted by courts or government agencies, where they're placed against the property without the consent of the owner. That's just liens in general. Number 193, a type of lien is called a specific lien. This only applies to a specific property that the lien is placed against, and most of the time, depending on the state, but most of the time, it can force the sale of the property to satisfy that debt. Remember, specific liens. Specific is the key. It's a lien that's placed against a specific property. So what are some examples of a specific lien? Well, I got them on your screen. They are mortgages, deeded trusts, property tax liens, special assessments, mechanics liens, and then attachments. An attachment is a type of lien that's placed against personal property. And if there is a creditor that is owed money, then they can file, they can get a judicial order for an attachment, so they can secure the personal property to sell it off to satisfy that debt. Homeowners association liens also can fall into the specific lien category that in most states can force the sale of the property to satisfy that claim. That is a specific lien. Now, a general lien is charged against the debtor's real and personal property. So general is not specific. Specific is the lien is specific to a piece of property or a personal property in the case of an attachment, but general liens are broad. So we see this as a result, for example, of civil lawsuits that have been filed against somebody. O.J. Simpson, for example, he was found not guilty in the criminal case against him, but he was found liable in the wrongful death suit, and general liens were placed against him. That included liens against his real property, his personal property, garnishments of wages, etc. But some common examples of general liens, again, depending on the situation, it can be federal income tax. Now, there are cases when federal income tax liens are specific as well, but generally they're general liens. Federal state inheritance taxes, child support, municipal liens, vendor and vendee liens, that means land contracts. These types of liens may or may not result in the sale of the property. That depends on specific state and federal laws. All right, so that is a general lien. Just remember, general liens are broad. They affect the person and also the specific real or personal property. Think about this. Typically, if you own federal income tax, for example, they're going to place liens against everything that person owns and can actually garnish wages. So, number 195 is what's called Lis Pendens. This means that literally means suit is pending or suit pending, meaning lawsuit pending. It's a public notice. And remember, when we have a public notice, lawsuits are filed with the county, and that gives constructive notice to the world of this pending lawsuit against a specific piece of property. It is just a technique that is used, a legal means that's used many times to stop the sale of a property until this lawsuit has been adjudicated. That is Lis Pendens. It is a key real estate term that we often see on the real estate licensing exam. If you're going to continue studying, check out this video right here. Don't forget to subscribe. See y'all in the next video.